Welcome to Who Wrote That Up for You, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual rather than the collective can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And we are live on Who Wrote That Up for You. Today is Wednesday, September 28th, 2022. I am Sonia Ebron, co-founder at Courtroom 5.
And I am Deborah Sloan, the other co founder at Courtroom 5.
We've got a terrific show for you today. In a few moments, we will speak with Mike Zouhri. He is the co-founder and CEO at PainWorth. It's a wonderful personal injury settlement tool that you'll want to hear a lot about. But before we get there, Deborah, what's our issue of the day?
I want to talk about once a week. I try to talk about things that make pro se litigants lose in court, or things that make self-represented litigants lose in court. And I talk about these things because I really want to be able to have people avoid some of the mistakes we've made. Everything we talk about, we've made these mistakes ourselves. That's how we know. And today's a big mistake or thing that pro se litigants might tend to do is false bravado. And that is things like not doing your research because you think you know what you before you go to court because you think you know what you're doing, talking about things you know nothing about, like admiralty law or sovereign citizens, things like that, where you've heard other people talk about it and they sounded very intellectual, but that if you don't understand it, don't take it to court, at all, and try to get it over on the judge. And another one is if you've got a set of facts on your side and they're very, very strong facts, and you know they are, and your opponent's argument is stupid, if you go into court like that and not challenge your opponent's arguments and just basically rest your case on the fact that your opponent's argument is stupid, you're going to be in for a big surprise when they win. And so, and then finally, not bringing a court reporter. We talked about this last week. We will talk about this again and again and again. You don't bring a court reporter because you think that, I'm just going to go talk to the judge, and the judge and the counselor for the other person, for your opponent. Oh, they're gonna hear what I'm saying, and then if it has to be appealed, they'll know. They'll be honest. Yeah. Think again. Anyway, those are some of the things of false bravado, ways in which you can lose in court because of your the way you come at it.
I tell you, I have absolutely, and I'm just thinking about the telling the judge your opponent's argument is stupid, and I have had that experience personally. I've done that. It doesn't work. It doesn't work. You've got to demonstrate it. Your judge may think the argument is stupid too, but if you don't show it, you don't win. So you've got to know your law and your argument, and you've got to show how stupid that opposing argument is. That's rough. The false bravado thing, though, is interesting to me. You're absolutely right about that. It seems like folks who, before they come to Courtroom 5 at least, are at two poles. You've got the folks who are going into court thinking they're going to see Judge Judy, and they just want to organize their facts and tell the judge what happened. And they often lose when there's a real judge there. And then the other side of these folks you're talking about who think they understand, they've done their research online and they've maybe found some sample filings or something they can just copy and paste. And they go in. I've actually seen a gentleman walk into court with a suitcase full of law school textbooks, and he was just going to pull them out as appropriate and read to the judge, how he should be thinking about these things. And it didn't work. Got
Yeah.
just completely shut down. And so it is really, really important to just get some skills developed before you head into court. Fantastic. Thank you for sharing that, Deborah. Really appreciate it. You all know that Who Wrote That Up for You is sponsored by Courtroom 5. At Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. And so, if you are in court without a lawyer, or you need to sue someone and can't afford a lawyer to represent you, get yourself over to Courtroom 5. We do things a bit different there. You'll find tools, training, and services. Many of them you can use on a limited basis for free. So we invite you to just check that out at courtroom5.com and see if we can provide some relief for you. With that, I'd love to bring onto the show at this time Mike Zouhri at PainWorth. Mike, thank you for joining. Who wrote that up for you?
It is my absolute pleasure to be here. Obviously, I'm a big fan of what you're doing over at Courtroom 5. So when I had the opportunity to join your podcast today, it was a no brainer.
So happy to have you here. Mike, you've got a classic founder story, a personal relationship with the work that you're doing as a tech startup. Would you share with our audience just what brought you to developing PainWorth?
Yeah, it's definitely a company I wasn't seeking to start. I think that's kind of what you mean by that classic founder story. I basically come from a world of tech and data science, but not a world of insurance and not a world of law. And in 2019, I found myself struck by a drunk driver who actually fled the scene of the accident. So yeah, it was pretty impactful on me, literally and figuratively. It left me bedridden for 6 months, and I felt like my whole world was over. Everything that I had worked so hard to build and do was sort of instantly stripped away from me. I didn't know how I was going to manage the rest of my life. I'm still, even to this day, left with physical injuries that will affect me forever. And I was really depressed. Now, the silver lining for me at the time was we did eventually find the hit and run driver, so we did track him down, and yeah, that was handled by the police. The problem for me, though, was when it came time to start discussing resolution of my case. Like, how do I actually resolve this case and settle it? And like most people, you know, I don't really know the justice system. I've never been in a situation like this before. I wasn't sure how to handle it, and it feels, the law as a concept feels overwhelming and bigger, and like you need a highly specialized professional. I grew up in an era where late night TV was just full of all these commercials, and you drive down the road and you see all these billboards for all these lawyers, and the psychological message to me was like, this is hard to do, but there are these professionals who do it, and that's why there's all this like money in the space, because everyone is hiring these professionals, which is why they're able to advertise, and that's what you need to do. That's the thing. Hire a lawyer. So I did the thing. I listened to a really cheeky late night infomercial, kind of convinced me to call, Larry the Hammer, or whatever his name was. And he was the guy who advertised he was going to fight to get me what I deserved. And I said, okay, sounds great. I'm not sure I can take this on, because people go to school for this, and I certainly didn't. But then I quickly found out that yeah, it's not exactly as advertised. One, the average case will take about 5 years to hit a resolution. So that's number one. Number two, you're looking at giving up about 40% of your case in values as a contingency. And number three, which is the part that really bothered me the most, is once you sign up, there's little to no customer service. Like, just like I could get a response same day before I signed up. As soon as I signed up, it was like months, like just nothing, no answers. Nobody gets back to you. You have no idea what the next steps are or where your case is at. Nobody gives you a wayfinder or a roadmap to what the process looks like and what expectations you ought to have. And I just got really frustrated. It felt like literal insult added to my injuries. So out of frustration, I took myself down to the law library, and I just started reading how to do it. And it turns out that it's not rocket science. Turns out it's actually like pretty straightforward. Settling a personal injury case. It's pretty well documented. It's very basic procedural, and most of it is negotiation. Like 99.999% of these cases never actually end up in court anyway. So you're not even really doing like legal court stuff. There's some paperwork and filing to like, show the other side that you're serious, but realistically speaking, you're not. I found it illuminating when I learned that in my jurisdiction, on average, there's about 15,000 motor vehicle accidents per year with personal injuries that can and escalate to litigation. But there's only 6 on average per year that end up in front of a judge, which also means that when you meet these lawyers who say, I'm going to fight like a lion, we're going to take them to court and we're going to get you what you deserve. Well, statistically speaking, they've never done it. 99.999%, it just hasn't happened. So if you were to take 100 lawyers and survey them, probably none of them have ever actually gone the gamut. So that was also quite illuminating. Like, oh, okay, there's a lot of marketing buffer on what's out there, and there's very little of that that's rooted in truth. So it really reframed my perspective as to like who can settle a personal injury case, how a personal injury case can be settled, and what sort of level of competence or prior understanding you need. I learned after I started befriending other lawyers and stuff like that, and many of them work for me now at PainWorth, that they don't learn this stuff in law school. In law school, you learn process and procedure for how to think about the law, but not actually any specific discipline of law. So, I also was suffering beforehand from this notion that, personal injury lawyers may be specialized like doctors. They learn this stuff in school. Not the case. Anyway, when I had all of these realizations back then, I felt empowered to do it myself. I said, well, I feel like I understand now, and I feel fairly confident that I'm not doing anything that's terribly difficult, and there isn't a lot of highly specialized knowledge that's required. I think I can take this on. So I started with the typical, 5 heads of damage that people look for when they start escalating their case. So pain and suffering, loss of income, cost of care, out-of-pocket expenses, and other non-pecuniary and non-pecuniary damages. So most of those heads of damages, especially the pecuniary, which just is like a fancy word for saying I know the price tag of it. Like I go to the doctor and he writes me a bill and I have a price tag on that, so I can seek reimbursement. The pecuniary stuff is pretty simple. You just sort of add up your expenses and then you multiply it by the number of years in the future that you think you're going to incur those expenses, and you have sort of a rough ballpark of what your pecuniary damages are. The non-pecuniary stuff, the pain and suffering, that was like really the X factor. Is like how do you put a price on pain and suffering? Like what's a broken leg worth? And turns out if you talk to 5 different experts, you'll get 5 different answers. Like there is no like formula, there is no math. And I thought that was a little silly. So what I did is I took all of the data from all of the court cases that existed, and I basically built a system that could read them all and then extract that data and turn it into a statistical model. So I could say, like, based off of this type of injury, here's the statistical model for exactly what that injury is worth. That way it wasn't so arbitrary.
Yeah.
I found in my experience that so many people had so many different opinions, and counsel might cherry pick high and defense would cherry pick low, and they would all do this as part of a dance for 5 years to eventually just meet in the middle. And I thought that was silly and a waste of time. But a statistical model that wasn't cherry picking, that read everything, could tell me the number, we could get straight to the point, and hopefully we could save 5 years of time. So I built that. That was really the core thing that I built, and I used that to basically settle my own case. And that was the start of what we now call PainWorth.
I
Wasn't
love it.
intended for anyone else. This was just me, just trying to
Your own
solve my
problem.
own pain.
Yep.
Yeah.
I absolutely love that, Mike. You've made very light work of my interview skills today, so I really appreciate you. You covered that so well. And first of all, I know that you're going to have lifelong injuries, both physical and psychological, from such a damaging incident. Really glad to see you, healthy relatively today. So that's fantastic. What I want to do, because there's this, I think so important for people to understand just the development of the tool and more importantly how it works. I want to take a quick break so we can do our challenge and quiz thing for a moment here, and then bring you back on to hear the rest of this and what you've built for people in a similar situation. Give us just a moment. We'll have you back in just a moment. Fantastic! I'm excited to get to the rest of that story.
Yeah.
Deborah, what is the what? Who won our quiz yesterday, and what do you have teed up for us today?
Well, unfortunately, we had no winner on yesterday's quiz, and it was kind of tricky, I guess. How could the question was, how can a defendant win a case after a plaintiff has proven? I'm sorry. How can a defendant win a case after a plaintiff has proven all the elements of their claim?
That was a hard question. I
I
knew,
know.
but I thought we'd
Even
get
for
at least
people.
one good answer. Go ahead.
Yeah, yeah. To win, the defendant must assert all the facts of one or more affirmative defenses and provide evidence for each one of those elements. And an affirmative defense, those are facts other than what the plaintiff has alleged, which, if proven, defeats or mitigates the legal consequences or any liability from for the defendant. So, for example, if a plaintiff has proven um, all of their all elements of their claim, a defendant can say, "Yeah, that's true. All of that's true. However, I'm not liable because I already paid the plaintiff." So that's one affirmative defense. There are a number of other affirmative defenses that could, quote, get the defendant, quote, off.
That's great. That's great. I suspect we'll see this question recycled at some point, and so you all have heard the answer now. So we expect somebody to come and win this thing next time you hear it. Fantastic.
Absolutely.
What's teed up for tomorrow?
Okay, tomorrow is a little bit easier. Today's question is, what does stare decisis mean? What does that mean? If you want to participate in this quiz, send your responses to quiz@courtroom5.com.
Fantastic, fantastic. Well, we expect some answers there. That's a quick dictionary definition. So should have hopefully a winner there tomorrow. Let's bring Mike back. Welcome back to Who Wrote That Up for You. Mike Zouhri is the co-founder and CEO of PainWorth. Mike, thank you again for sharing a very painful story of your accident and your recovery, and then how you went about resolving the claim. You built something from that very painful experience that now can serve millions of other people who have a similar circumstance. Tell us, please, what is PainWorth? Who's it for? Like, who does it serve? And yeah, how does it work?
So, PainWorth is an artificial intelligence platform that helps people calculate, manage, and settle their personal injury case without the need for any expensive middleman. And the reason that I don't say the word lawyer or anything like that is because when I talk about expensive middlemen, they could come in the form of independent adjusters, they could come in the form of like hired counsel. And it's also important to note that they work on both sides. So oftentimes when you're dealing with a personal injury case, the the large the largest number of personal injury cases just happen to be motor vehicle, and motor vehicle is almost always indemnified by an insurance company. So we're really often talking about a person versus an insurance company. Technically, it's a person versus a person, but for anyone watching or listening who doesn't know, the defendant person is indemnified by the insurance company who takes over. So that's what I mean when I say indemnified. So um, we have two sides on the same table trying to resolve a case, and both parties don't inherently trust one another. And that's part of the root of the problem. And there's a lot of good reason why they probably shouldn't trust one another. Their financial interests are on opposite sides. So that's fair. But in order to reasonably settle a case, you really just need to know how to evaluate the case and then how to package the evaluation with all the evidence. And that's really it. The rest of it just comes down to negotiating around those two things. But those two things can be quite daunting for an average person who's never been in that situation before. You fear what you don't know, and people have an anxiety about doing it wrong. And I had that same anxiety. It was like, well, there are experts, so they must know how to do it, quote unquote, right. And if I don't do a thing, I might be doing it, quote unquote, wrong. So you're sort of left in this situation without a tool like PainWorth, where you can either try and take it on yourself and feel like you're outgunned, or swallow the pill and you hire one of these middle people to get involved and look after your interests, regardless of what side of the table you're on. And the problem with that is, once one side decides to escalate in that manner by seeking, the other side reciprocates. So we end up with a situation where if you have $100,000 settlement on paper, you'll pocket as a claimant about $60,000 after 5 years. The interesting thing is, I thought that's who I was exclusively serving, but I found very quickly that the other side also has this weird problem where that $100,000 check that they write doesn't cost them $100,000. In Canada, it costs them $180,000, and in the United States, it costs them a grand total of $250,000. So the reality of a personal injury case where the settlement is $100,000 is that the insurance company pays out $250,000 to put about $60,000 in someone's pocket. So there's two sides that actually equally lose out, and they get really angry at each other. And the truth is, if I could figure out a way to get them to behave nicer to one another instead of going through an adversarial approach into a more collaborative and understanding approach, we could put more money in both pockets. So the claimant could settle a case on his or her own 5 years faster for, let's say, $90,000 in pocket, and the insurance company total cost might be $120,000. So it's like this huge win-win. So the platform started very one-sided, but now the platform has evolved to bring in both sides. So what happens is somebody will log in onto the platform and start their own assessment based off of all of the facts they know. Our system will research case law to find the valuations for that, and then help the person package exactly what the valuation was. Once that package is formulated and put together, it comes with a list of instructions and next steps to do. And then you can share that with the other party. And then the other party can very transparently see everything by line item, and also where that number comes from. So it's not good enough to say this is $100,000 case, because then people will be like, no, I think it's a $70,000 case, or $150,000, whatever. It's more important to show the why. So it's $100,000 because here's the 10 cases, and because here are, the audit trails, and because here's the prejudgment interest and the inflation and the, whatever other calculations we do, the mileage and the the economic assessments and blah blah blah. And so we'll package that all in, and then it becomes less about the number and more about the inputs to calculating the number. So now the discussion and the negotiation becomes, well, is it really a catastrophic injury, or is it actually just permanent and long lasting? And we're trusting the system to calculate it. So we're not negotiating, pennies anymore or dimes. We're just focusing on the quality of the actual inputs. So that's where the platform is today as a state, and that's very different than what I thought we were building when I started.
Got two questions for you here. Then, one, the the cost reduction for the insurer is coming out of lawyers' pockets, right? That's money that they're not having to spend over 5 years to a lawyer. You have got to have crazy blowback from the personal injury bar. Tell me
No.
then, tell me why not?
So it doesn't in practice work out that way. So the natural reaction is like, that must be it, and lawyers must hate you. Turns out I have a ton of lawyers who are big fans and use the platform themselves. Number one, the platform just cuts down on cycle time. Things that used to take 5 years might now take only a couple months. So the cycle time reduces, which is a huge advantage to the lawyers involved. Lawyers do often use that platform because it means they can get their payday faster. The other thing to remember, I guess I should have started by saying, is PainWorth is not great for claimants with claims over $150,000, which is where lawyers really come alive, is like sort of after that dollar amount. Anything below that, it's really just a lot of paper pushing. A lot of these lawyers that I know and that I work with went to school, with a vision of doing something to help people, and now they find themselves in this practice of law where many of the files feel very boring, repetitive, and like almost like just pushing paper back and forth. They don't get excited by their files. The files that really excite them are the $1 million files and the
Mhm.
$10 million
Right.
files. They require creativity, and they require flexion on their part. But they don't see that with the majority of cases. So we're really good helping claimants below $150,000. The
Mhm.
software works for any dollar amount, but the thing about that $150,000 threshold is, like, a claimant with damages greater than that probably has significant damage and probably just doesn't have the wherewithal to go through it.
Yeah.
So we tell claimants like that you're probably not going to do this on your own. You
Yeah.
probably need to focus more on your own recovery, and you're probably going to need a human helping you out.
That's
So
great.
for a lot of lawyers, they look at PainWorth as being a feeder system for those more high value claims. And on the
That's
insurance side, it's the same sort of case. Insurance companies are like, well, isn't this? And we're like, no. You're not going to get out of litigation on $1 million case. Just like you, like, accept that.
understood.
And
Yeah.
they all recognize that. They're like,
Yeah.
yeah, we know litigation is definitely happening on these $1 million cases. So if it is going to happen, let's make it happen smoother and faster and get everyone resolved quicker.
Real
They
quick,
they
real
actually
quick, Mike.
lose.
Mike, yeah, we've got about a minute left.
Oh,
Sorry, to
sorry.
cut you out. That's okay. That's okay. I just wanted to ask you real quick, where are you available? You mentioned Canada and the US. Is that nationwide, or are there
Yeah,
specific territories that you
yeah,
that you
so it's nationwide in Canada, and we're doing staged rollouts in the United States. So we
awesome?
actually have about 20% of our users in the United States using the product already in jurisdictions where it doesn't technically work.
Hmm.
So the system works, but it doesn't have data specific to that jurisdiction.
Gotcha.
So
Yeah.
yeah, it
Last
helps,
question.
but it's not. Yeah.
Where can people find you online? I'll share your website here, but where else can folks find you online?
You can find us at painworth.com. So, like, what is your pain worth? Painworth.com. Um,
Fantastic.
Obviously, we're super passionate. You can probably pick that up in our call today. I've got so
Yes.
much to say, but it's
Yes,
all
that'd
on
be
the
great.
website. So,
We'll watch your progress, particularly here in the U.S., and we'll have you back on. Mike, thank you so much for again transforming your personal injury into a personal injury tool that can help millions of people. Thank you so much for joining Who Wrote That Up for You.
My
Awesome.
pleasure. Thank you
Thank
for having
you.
me.
All
You
right.
bet. All right. Fantastic.
Oh,
That's all we
that
have.
was great.
Yep,
Okay.
yep. That's
Yeah.
just fantastic, fantastic story. Really appreciate Mike for sharing that. But that's all we have for you today. As always, we will see you on tomorrow. Thanks for joining Who Wrote That Up for You.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.